the IRS website, you don't have to use it. You can design your own form, your own affidavit, and as long as it has the same information that is on that W-11 form, and the employee is signing under penalty of perjury and acknowledging that they did not work more than 40 hours during the last 60 days, then you're fine. The affidavit does not have to be notarized. You don't send the form to the IRS, you just keep it in your own file, but you must have the affidavit. If you don't have the affidavit on file for someone for whom you're trying to claim the tax benefit, then you don't get to take advantage of the exemption. So it is important to make sure you've created that paper trail by getting that affidavit signed by persons who you intend to designate as qualified employees. You don't necessarily have to have that affidavit on the first day the employee works for you, or even the first week necessarily that that employee works for you, but you have to have the affidavit in your files by the time you file, the employer files an employment tax return applying for the exemption. So whenever you submit that, you better have that affidavit in your file, excuse me. The information published by the Internal Revenue Department does allow that an employer can get the signature by use of an electronic signature, and they say that that is acceptable. If that is a procedure you're thinking about using, then you'd want to check the rules more closely, or check in with us here at ESG Republic to get a little more detail on that, because there are some specific requirements that are outlined in the rules to have an acceptable electronic signature. So that's a detail you'd want to follow up on, but at least I wanted you to know that that is a possibility for an employer. One question that has come up is whether the employer can take advantage of this, the payroll tax exemption, and also take advantage of the COBRA premium credit that has been in effect until very recently. That was part of the ARRA that was published or signed into law last year. And the answer is yes. You can rehire an employee who was laid off last year and for whom you, even as the employer, have been taking that COBRA premium credit, so long as that employee is a qualified employee. That is, so long as that employee has worked less than 40 hours in the last 60 days, then you can both get the benefit of the payroll tax exemption for rehiring this person, even though you were already taking the tax benefit from the COBRA premium that had been in place until very recently. So you can take, in a sense, I'll say double dip, I suppose, but you can take advantage of both of those opportunities that have become incentives for employers to get people back to work. Some unique questions that have come up regarding the application of the payroll tax benefit. The law does say that the exemption does not apply to household employers. So if you're an employer or person who wants to hire people for your household, this is not a situation where you can apply the payroll tax exemption. But it does apply to employees who are hired for a new business. So there's people who are in and people who are out in terms of the application of this payroll tax benefit, but it's going to apply to really most of the private sector employers who have the opportunity to bring more people on board. So that's kind of maybe an overview, I suppose, of both the payroll tax exemption as well as the business credit. Let's talk a little bit more about how the exemption will really work on a day-by-day basis. As I mentioned before, Social Security normally is paid at 6.2% of the first $106,800 of wages during a calendar year by the employer and employee. So that's the amount of base wage that the Social Security tax applies to. Now the employee pays 6.2%, and then the employer matches that 6.2% as well. And so this exemption that we're talking about is the employer side of that. The employee still must pay their 6.2%, but the payroll tax exemption is to that 6.2% that the employer would normally pay, and so for a qualified employee, the employer will not have to pay that portion. That's the exemption and the tax benefit that we're talking about here. The employer still needs to pay, though, the percentages that they normally would pay for the Medicare hospital insurance, FUTA, unemployment insurance. In California, the FTDI, or the paid family leave deduction that is taken out of every employee's paycheck every month. All of those things must continue to be paid in full. So this exemption is only applying to this Social Security 6.2 match that the employer would normally pay. This will apply to wages that have been paid between March 19 and December 31. So we have to remember here that the focus is on what wages have been paid, not necessarily what's just been earned. And so for the first quarter of 2010, the wages subject to the exemption may include wages earned before March 19 but are paid after March 19. Because a person could begin work, on or after February 3rd, which was the date I had given you earlier. They could begin work after February 3rd, but not be paid for that time until after March 19, and then be eligible for this exemption. On the other hand, wages that were earned before March 19, even though they may have been earned after February 3rd, but were paid before March 19, you're not going to be able to take advantage of the payroll tax exemption for those wages. So we have to watch these dates in terms of the applicability. But now we're already, into June. So, for new employees who meet the definition of a qualified employee that are, being hired this month and in the ensuing months, we don't have to worry about that whole March 19, February 3rd issue because we're well past that. But when you're trying to apply this law to employees who are hired right around that time, when you have to be careful about when they were hired, when they were paid, and what the wages, what time period the wages were earned for. All right, so that's how we'll apply that part of the exemption. In terms of how you actually then submit the exemption or apply for the exemption, you'll claim the credit on your Form 941, which is the employer's quarterly federal tax return that you're already familiar with. Credit for the first quarter of 2010, because the first quarter, of course, ran through the end of March, and these issues we're talking about here, overlapping here in that February 3rd to the March 19 time frame, some of that is encompassed in that first quarter. But yet, we didn't even know the law was going to be there. We didn't have the forms available to do that. So you really couldn't take advantage of this on your first quarter federal tax return that you filed. But you will be able to take advantage of that for the first quarter when you file your Form 941 for the second quarter. And the form is designed to allow you to do that. So the credit may not be realized right away. But it will be realized once you file that form for the second quarter. That will also then cover the first quarter. And then for wages paid after April, once we get into the second quarter, then you're just going to be credited on a payroll period by payroll period basis. So every quarter you will file those returns and take advantage of that opportunity. To take advantage of this payroll tax exemption, you have to apply the exemption on the return for the quarter in which the wages were paid. So you're not going to be able to get to the fourth quarter and then retroactively try and claim the exemption for the previous quarters where you might have had qualified employees but didn't take advantage of the opportunity. So it is something that, based on the rules as written right now, that you're going to want to stay on top of, on a quarter-by-quarter basis through the 2010 calendar year.